Good morning, everybody. We're here with my dearest professor, Miss Christine Bartholomew. She was my professor of evidence here at UB. She's also has won the prize for the best professor at the law school for 7 years in a row. In the law school or in the university?
Law school, yeah.
Okay, and she's also the chancellor for SUNY here in New York, and and she's also the vice dean for academic achievement nowadays, right?
Mhm.
So, Professor Bartholomew, I'm very happy to be here with you again. I had the opportunity to be with you in class this morning, and so hello, thank you for being here.
Thanks so much. It's lovely to see you again.
Awesome. So, Professor, I wanted you to share with the Colombian students a little bit about evidence. So I want you to explain us a little bit about hearsay evidence, right?
Sure.
Why don't you explain us what hearsay evidence is and what are the elements for hearsay evidence?
So for hearsay, there are three elements. We need to have a declarant who makes an out-of-court statement that is offered for the truth of the matter. So three separate things: a declarant, out-of-court statement, truth of the matter.
Okay, so when you talk about a declarant, does that statement produced by someone has to come from a specific, person, animal, computer? Does it has any requirements?
So it has to be by a human, and it seems kind of like a silly thing to think about as a requirement, but we have had cases where, for instance, a parrot has heard testimony, and then with the parrot repeats it, is that a declarant? And the answer is no, because an animal is not a human. It sounds silly, but this can come up. Where it really becomes more interesting, I think, is what are we going to be doing with artificial intelligence? And we are still grappling with that very question. If something is machine generated, like a receipt, that's considered not a declarant because it's not human. But the line between when something's machine generated and when it's a human statement is something I think that you and I will be talking about for a long time, and something the courts are going to still be working through for the next easily 3 to 5 years.
Okay, so have you had the opportunity to see any case with artificial intelligence already or not?
Yes.
Oh,
yes. Really? Mm-hmm. And at that point, there is considered sufficient human interaction with a particular artificial intelligence to be considered still human, because it's the degree of involvement. And in the proceedings, at least to date, human intervention still matters. The U.S. will be creating will be issuing initial principles on this probably within the year. There's a committee that's meeting in fall to work on the drafting of such basic principles. My suspicion is that the principles are still going to be pretty broad and may not address specifically hearsay, but I think that it's going to be a starting point for our assessment.
Oh, how interesting. Now, let's move on to the statement part. Does the statement has to be written, can come from another witness, can come from a nonverbal act? How does that work?
All you need is an out-of-court statement. And that means that we are looking at when the statement was first made. The very first time the statement was made, was it made out of court?
What if, say, I am the person going to trial, and I made a statement out of court, and then I am taking the stand, and the judge asked me for something I said before. Is that hearsay statement, or is it not a hearsay statement?
The first time you said it, it was out of court, so it satisfies the out-of-court statements. In other words, it would be treated like hearsay. It can be a photo, your words, something in writing, anything, so long as when it was first generated, was it out of court. It's very broad.
It means that the form of the statement, it doesn't matter how you record it. Even, I mean, if you have the writing, or if you have recording, or if you have someone bringing the information, it doesn't matter the way you have it. Every statement produced out of court, it becomes to be hearsay evidence?
Yes, it's quite broad. Now, of course, some of the modalities that it comes in might implicate an exception later. But for the first question of whether it is hearsay or not, broad statement does not mean any particular form. All we care was, were you making an assertion, some type of meaning? There are some instances where we decide something's not a statement.
Mm-hmm.
If you say, huh, is huh
A declaration?
Well,
assertion?
are you asserting any meaning?
Right.
You might not be.
Right.
And so we're going to recognize that that's not necessarily a statement. But remember, when we say statement, even includes nonverbal. So if you ask me a question and I nod, me nodding means yes.
Right.
And so if I nod the first time you ask me this question out of court, I have now made an out-of-court statement.
Oh.
And so even if you ask me in court about it later, a hearsay objection would be appropriate.
Or for instance, when someone asks, who killed the victim, and someone points out, then that's an assertion as well, right?
That's correct, because it has a communicative component. So a statement can be verbal, nonverbal. It can be anything that has communicative factors to it. We simply care, when did it first happen, and are you attributing some meaning?
Okay, that's awesome. And so I want to move on now to the third element that composes hearsay, and I, this tricks me a lot, because this is a component that is not considered in the Colombian rule, but is the truth of the matter asserted clause part of the hearsay evidence. How does that work?
Oh goodness! So in addition to having a human declarant who makes an out-of-court statement, you also need that statement to be offered for what we call the truth of the matter. This is probably the single most important component of hearsay.
So, sorry to stop you there. So that means that it's not enough that you have an assertion or a statement that is produced out of the court. You also need it to be offered for the truth of the matter? That's what you're saying?
Correct. They're elements. You have to have all three before it can be labeled hearsay. If you just have two, it's not hearsay.
Okay, good.
So truly, so what courts have to look at is, what are you offering this statement for? What's your purpose?
Right.
And it ties back to relevancy, which is
right.
The very opening question in any case. In the hearsay analysis, you still have to go back to, what is it that you're offering it for? And if you're offering it, for example, just to show that the words were said, not because it matters for an element, factor, or defense in your case, that's not hearsay. So we've identified kind of 5 categories that fill in as exemplars of when something is not for the truth of the matter. And in those instances, they're not hearsay. And I think sometimes thinking about when something's not for the truth of the matter gives you a sense of what those words really mean, and also illustrates why they have such power in this context.
Right.
So for example, if you're offering a statement for impeachment, it's not for the truth of the matter. It's just to show that someone said something different before. So if, like, we've got car accident, right? And you initially said the light was green, and now you're saying the light is red,
then that's not hearsay.
Correct. Because
Okay.
I'm not offering it to prove what color the light is. I'm offering it to prove your words keep changing.
Okay.
But now, the very same phrase. What if I offer it because I really do want not only to prove your story changed, but
the light was in fact red.
correct.
Right.
Now, if I'm offering it for that purpose, suddenly the very same piece of evidence now is for the truth of the words. The truth of what I'm offering it for becomes hearsay for that purpose. If it's just for impeachment, it's not hearsay. So you can see that that phrase has, it really is critical to determining the admissibility standard. So other examples, verbal acts, not for the truth of the matter.
What's a verbal act,
Yep.
so people understand?
Verbal acts are words that have legal power. So if I tell you, this is a gift, it's yours forever,
Okay.
right?
Yeah.
The fact that I call it a gift means it is.
It
It
is a
has
gift.
power.
So you're not charging me for
I'm
giving
not
me this.
charging. But what if I didn't mean it?
Okay.
Well, if I didn't mean it, who cares? Because the words themselves had power. You're not offering. Now, if I say, oh my gosh, you're a thief, you took my Vulcan, whatever this is, you took my toy.
Let's put it here.
And you're offering it, and you say, no, but Christine said it was a gift. Well, that now has verbal power. It doesn't matter if the words were true. What matters was the words were said. So at that point, the phrase "this is a gift" is being offered for its legal effect.
So, for instance, when I call someone things, when in a defamation case, say I call a person corrupt, or he's a thief, a theft, or what have you, then those words are admissible as not hearsay, as long as I'm not bringing them in to show they're actually a corrupt person, that he has stolen somebody else, but to demonstrate that these words were said.
Correct, because those words, once you said them, have a legal effect. They create a claim for defamation, and because a legal effect is a type of verbal act, it's not for the truth of the matter.
Crystal clear. Let's move on. Do we have other ways of understand?
Effect on hearer. Sometimes words are offered because you want to understand what the person who heard the words might think. This is really, really a big deal when you're talking about words that are offered, testimony that a police officer may have heard. If you were an officer and I say to you, Juan, there's a robbery, it just happened down the street. If the question is, did the police officer have probable cause to go investigate down the street? It doesn't matter if what I said was true or not.
Right.
You now are going to go check to see if there was a robbery down the street.
Yeah, of course.
Now my words are not for the truth of the matter.
Oh.
But if you're offering the same thing, my words, to show there actually was a robbery, not for the effect on the person who heard them, and it is for the truth of the matter.
And then it's hearsay, and then you have to strike it out.
Correct. And so you really have these kind of pivotal questions. What are you offering it for? Now, what if you're offering it for both?
Right.
Well, you might need to exclude it for one purpose, but not for the other. And then that'll require a limiting instruction and trigger a whole series of other questions as well. So effect on hearer is another one. Another one is circumstantial evidence of the speaker's state of mind. If I say, I am, do you have Peppa the Pig?
Yeah.
Columbia? Okay. If I were to say, I am Peppa the Pig, and you're offering my statement to determine if I'm in the right state of mind to make a will, you're not offering it to prove I'm truly Peppa the Pig. No, but those words have circumstantial value to know if I could have the right state of mind to make testamentary documents. Not for the truth of the matter.
Awesome. So one hint for my students, I always make this question in my exam. So if you hear this, then you take note, because you will take advantage of it in your exam. And do we have any other exception, or these are not exceptions? These are expressions of the truth of the matter class, right?
I think those covers the main ones to think through, and it's really more of just examples of ways to understand or think about when something's for the truth of the matter. The way I work with my students, as you remember this, every time you hit a hearsay question, for sure you're going to think through, do you have a declarant? Is it an out-of-court statement? But your assessment for the truth of the matter, it should be consistent with whatever analysis you thought through for relevancy.
Right.
And that's a great check. So if it's probative for an element, factor, or defense, then okay, which one? And if you can still have it have value without the words being true, you may not have hearsay on your hands. But if you need the words to matter, if you need the words to have actually be accurate for it to be relevant, okay, you may have a hearsay problem.
Right. Let me ask you real quick about two more topics.
Sure.
So in Colombia, the exception, the hearsay exception, works only or mainly where the witness is unavailable. Here is the same case?
Well, we have hearsay exceptions for when the witness is unavailable, but I also have over 30 other exceptions where I don't care if the witness is available. So we actually have, so you go through first, is it hearsay? Then we have a category of instances that we call statutory non-hearsay, where there's specific statutes that say, even though it's hearsay, we will treat it as if it's not. After that, we have what we call unrestricted hearsay exceptions. Again, I don't care if the declarant is available or not, and we have a good number of these. Most of our hearsay exceptions that apply in case law in the U.S. are unrestricted.
Okay.
Very, very, very common.
So you were saying that when the witness is even available, you don't care. You have more than 30 exceptions, right? So in Colombia, overall, we only have 5 exceptions that make hearsay evidence admissible.
Oh,
so
gosh. Well, you probably have the unavailable ones. So for us, under 804, we have the unavailable ones, and that is 2 parts. First, you have to prove that they're the right type of unavailable, because unavailable is limited. And then even then, we only have some limited exceptions for unavailability.
Right.
In the States, the hearsay exceptions that come up the most are things like business records, recorded recollections. All of those, we don't care if you're available or not. You can literally have the witness on the stand right there and still get a potential hearsay exception.
So can we go through real quick to explain what multiple hearsay is and how you overcome these difficulties?
Okay. So
this is like the really basic concept.
Sure. This comes up a lot. It really comes up a lot in documents. So multiple hearsay is when there are more than one level of hearsay within hearsay. The basic rule is you start first in time. When was the first statement said? Let me give you an example first. Let's say that you are a customer and you came to me to make a complaint about something that you purchased. And I'm going to give you a refund. I'm going to potentially fill out a form. And you first tell me this product doesn't work. I write down, customer says the product doesn't work. Well, now the form, if that form was offered as evidence, I have your statement to me, what I wrote down, which is memorializing it, a second level of hearsay. For it to be admissible in the US, both levels of hearsay have to come within an exception.
Otherwise, they won't come in.
Correct. And
so you have to go first to the statement that I gave you.
First
in time.
To
fall in an exception, and then we have to prove that the form itself falls into another exception, right?
Yes. And so I think of it like nesting dolls, or those little dolls you stack on top of each other. Every single level.
Like the matryoshkas in Russia.
Correct. Exactly. Every single level must fall within a hearsay exception. And if the third one doesn't, the fourth one's not coming in. Once one level doesn't satisfy, the next levels don't come into.
Okay. So last and not least, I think this should have been the first question of all. But what's the rationale behind hearsay evidence? Why we mainly don't want to accept hearsay evidence into trial?
Because when we are concerned with hearsay evidence, that we didn't get a chance to assess the declarant, their credibility, their word choice, their facial expressions. We didn't get all of that component when they first made the statements. And the idea is it's just not as reliable evidence. We want the fact finder to be the weighing the witness and viewing all of this kind of nonverbal communication component and determining truth. So if you've got a statement that someone makes, but they repeat it in courts, they've had 2 shots to try to make it sound plausible. We want to hear how they said it the very first time. I guess I always think about it, as you know, I'm a parent, but I think about when I like to kind of catch my kids on things, right? Like, they think they're so clever. I have 17-year-old twins. They certainly think they're clever. But if I ask them, if I ask my daughter, did you take the car out last night? I might get an answer of like, no.
Right.
The second time I ask, did you take the car out? No.
No?
Because we as humans.
She learned how to improve the answer.
Yes, exactly. And this is the real risk that people have with hearsay.
Right.
Is that your story becomes cleaner and more linear the more times you tell it.
Right.
Documents, statements, pictures, all of this. You have a chance to kind of clean it up. We want to look at it in its pure form, and the hearsay rules are intended to deal with that. That said, the reason there's so many exceptions is in recognition that, can you imagine if you just took everything out, how would you ever figure out the case?
Right.
So we have these concerns with genuineness, with fact finding. We want to engage in true cross-examination. So we have to balance that with our overall fact-finding mission, and that's kind of hearsay is intended to reflect this balance.
Yeah, and that's what happens when you bring a recording where you have the witness saying things behind the camera, or you have a writing. Well, you have the information, but you cannot cross the person and try to get out what he's really saying and if it's true or not, right?
Correct.
And also when a witness comes and tells what another witness really told him about an episode, right?
Well, now I'm concerned for both of them. Was the initial person telling the truth? Did the second person really understand what they were saying? We have a lot more.
Right. Through a double analysis, right? Well, Professor Christine, thank you so much for giving me this time, for explaining to the Colombian community about this hearsay exception. I really wanted you to have the opportunity to share with our students these things, and I'm very happy to be here with you again and get to see these all concepts coming alive with your explanations. It's been a really, really, really interesting time.
I really appreciate it. Thank you so much.
Okay, bye. So to you guys, I hope you enjoyed this episode, and you can get to see and study a little bit more of hearsay evidence now that you have heard this very crystal clear explanation from Professor Bartholomew. Thank you so much.
Thank you.